Right. My informant tells me that he just can't wait to hear about these other motions that were filed by Mark Richards' team in the Kyle Rittenhouse shooting. So I'm going to go ahead and go over it. I already did the first motion. If you missed that, go back to one of my previous videos. I think it was like a couple of days ago. I recorded that one. And we're going to go to motion number 2. And it says the defendant has no objection to the state's request. I'm going to go back and see what that is about, but obviously not much of any big deal. Richards is not even objecting to it. Motion number 3. The state requests the defense be prohibited from introducing any prior acts of Joseph Rosenbaum, Anthony Huber, or Gage Grosskreutz that were not personally witnessed by the defendant. The state opines that if the defendant did not know about something these individuals did, then it could not be relevant to his self-defense claim. The state views the events that unfolded throughout the evening as other acts evidence. Mr. Rittenhouse is charged in count 1 with first-degree reckless homicide in the death of Joseph Rosenbaum. The elements of that charge are set forth in Wisconsin J.I. Criminal 1020. The third element of that charge requires the state prove that the circumstances of the defendant's conduct showed utter disregard for human life. In determining whether the circumstances of the conduct showed utter disregard for human life, consider these factors: what the defendant was doing, why the defendant was engaged in that conduct, how dangerous the conduct was, how obvious the danger was, whether the conduct showed any regard for life, and all other facts and circumstances relating to the conduct. And he has a citation for it. The facts and circumstances of what was happening in Kenosha that evening are highly relevant. The complete and utter chaos is relevant for the jury's determination of whether Mr. Rittenhouse's conduct rose to the level of criminal recklessness. For example, Mr. Rosenbaum's conduct of screaming for people to shoot him, screaming racial epithets, yelling that "I just got out of jail and I don't care if I go back," along with him carrying a security chain and a gas bomb, should be considered in determining whether the defendant's actions were reckless. Kenosha was rightfully described as a war zone on August 25, 2020. And actually, he probably should cite sources for that. The city was burning to the ground. Police, fire, and rescue were not responding to calls. The state reserves the right to call the events leading up to the shootings peaceful protests, if that is in fact what they were. And it's pretty clear that if the state introduces the term peaceful protest during the trial, that's definitely going to open them up for allowing this kind of testimony. But we move on. The lawless behavior that night, including Mr. Rosenbaum's behavior, are part of the overall facts and circumstances for the jury to determine whether the defendant's conduct under the circumstances was criminally reckless. Furthermore, the state has charged Mr. Rittenhouse with first-degree intentional homicide by use of a dangerous weapon relating to Anthony Huber, and attempted first-degree intentional homicide by use of a dangerous weapon regarding Gage Grosskreutz. Both of those counts require the state establish an intent to kill. According to Wisconsin GI Criminal 1016, you cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all of the facts and circumstances, in this case, bearing upon intent. Much like the third element of first-degree recklessly endangering safety, which states that all other facts and circumstances relating to the conduct are to be considered, a fact finder is directed to consider all the facts and circumstances bearing upon intent in the charges involving Anthony Huber and Gage Grosskreutz. To exclude relevant testimony and evidence which touches upon each of those elements would be improper. The acts of any of the rioters, including but not limited to Rosenbaum, Huber, and Grosskreutz, would be relevant in determining whether the defendant's conduct was either criminally reckless, intentional, or both. trying to bar witnesses from testifying about the behaviors of each of those individuals throughout the evening by describing it as other acts is illogical. It is the same course of conduct of each person throughout the chaos that was Kenosha, Wisconsin on August 25th, 2020. So let me make this short for you. Joseph Rosenbaum and Gage Grosskreutz and Anthony Huber engaged in some nefarious activity throughout the night before they encountered Kyle Rittenhouse. With the case of Gage and Anthony, it's not quite so clear how criminal or reckless their behavior was. However, Jojo Rosenbaum was berserk. There are witnesses claiming he did a lot of really nasty things, trying to set buildings on fire, trying to set garbage cans on fire, calling people names, trying to get into fights. And the prosecution is trying to claim that you cannot bring those things up because Kyle did not necessarily know that these events occurred. And of course, the defense wants to bring them up, and this is what the motion is all about. So what do you think? Do you think that the judge will grant the motion to have this behavior of Joseph Rosenbaum and to a lesser extent Gage Grosskreutz and Anthony Huber introduced into the trial? Write in the comments below. I'll have the rest of the motions coming up in forthcoming videos. Like my video and subscribe to my channel.